5 seconds to go. Start. The plaintiff claimed title over the property through Chiruthi, who was his mother, and he was born from her second husband. The foundation of Chiruthi's title was claimed to be the registered lease deed bearing number 2329 of 2010, Exhibit A1. Kuti Peravan, who was the second lessee in Exhibit A1, had later released his right in the subject property in favor of Chiruthi and Sanskaran, the latter being the son of Chiruthi through her first marriage. That deed was executed on 22nd July 1925. The first appellate court, relying on the mortgage deed dated 7th May 1900, found that it was Madhavan and his mother Nangali who were holders of gen right and that they were in possession of the subject property even after execution of the mortgage deed. The first appellate court disbelieved that the deed of 22nd July 1925 was in discharge of liability under the mortgage deed. It was also found by the first appellate court that Chiruthi had no authority to create a lease and such a transaction by which she sought to lease out the subject property was not permissible in law. As regards Chiruthi's right or title, it was held that she would not derive title to her deceased husband's property when she got married again to Nilaknandan. The first appellate court has referred to Section 2 of the Hindu Widows Remarriage Act 1856 Act, which prevailed at the material point of time when she contracted her second marriage. Section 2 of the 1856 Act reads, all right and interest which any widow may have in her deceased husband's property by way of maintenance or by inheritance to her husband or to his lineal successors or by virtue of any will or testamentary disposition conferring upon her without express permission to remarry only a limited interest in such property with no power of alienating the same, shall upon her remarriage cease and determine as if she had then died, and the next heirs of her deceased husband or other persons entitled to the property on her death shall thereupon succeed to the same. The first appellate court did not attribute much importance to Exhibit A20, which is the first of the two deeds, which was executed in the year 1910 while referring to Section 2 of the 1856 Act. The first appellate court has rightly come to a finding that Chiruthi had only a reversionary right over the suit property held by her first husband Madhavan, and the plaintiff Chandu could not claim partition right on the strength of his being a uterine brother of Sanskaran born to Chiruthi after she contracted her second marriage. She lost all her rights and interests in her deceased husband's property on contracting second marriage with Nilaknandan. There is an authority on this position of law. Section 2 of the Act of 1856 therefore has taken away the right of the widow in the event of remarriage, and the statute is very specific to the effect that the widow on remarriage would be deemed to be otherwise dead. The words as if she had then died are rather significant. The legislature intended, therefore, that in the event of a remarriage, one loses the rights of even the limited interest in such property, and after remarriage, the next heirs of her deceased husband shall thereupon succeed to the same. It is thus a statutory recognition of a well-reasoned pre-existing Shastric law. Stop.